Your bank accounts can throw you into probate unless you've structured them properly. In this video, I'm going to go through the strategies that you should be implementing to ensure that your estate doesn't end up in probate because you haven't thought about your bank accounts. All right, let's get started. Okay, so here's the deal. When you pass away, if your bank account is still titled in your individual name, then that account will have to go through probate in order to be distributed to your beneficiaries. And the problem with this is that whenever someone dies, and I've been doing this for over 23 years, and I've seen it happen many times, that when someone passes away and they have a bank account in their own name, typically what banks will do is freeze that account. Now, here's a problem with that. Let's assume that those funds that are inside of that account are needed to possibly pay bills associated with your estate. Maybe your beneficiaries need some of those assets immediately to cover expenses with your passing, or maybe they have personal expenses that they could really use those funds for. When banks freeze the funds, you or your estate will lose out. So, what are some of the solutions that you hear people talk about when it comes to bank accounts to avoid having them fall into probate? Well, number one of the things I hear a lot is to set up these accounts as joint tenancies with right of survivorship. Now, if I were you, I would avoid that advice at all costs. In fact, my mother-in-law several years ago, we're talking 18 years ago, was sitting there and she tried to convince my wife to go on to her bank account, her checking account, as a joint tenant. And she explained to my wife that, hey, by making her a joint tenant on the account, per the advice of her banker, if anything was to happen to my mother-in-law, then my wife would then be able to take over the account and manage the account. Okay, so that is accurate information. If she does pass away, my mother-in-law that is, then that account right there would then become my wife's account. That is, my wife has an ownership possessory interest in that account that would automatically invest into her name as soon as my mother-in-law passed away. So all my wife would need to do is show a death certificate, and then she could step in and she controls the account, and the bank will not freeze those funds. Now here's the problem. As I explained to my mother-in-law, if you put someone on your account as a joint tenant because you think, hey, this is a probate avoidance that I'm looking for my bank account, what you're doing at the same time when you make them a joint tenant is you're giving them ownership of your account. Yep, people don't realize that. So here's what can happen. As I explained to my mother-in-law, if my wife was involved in a lawsuit and a judgment was entered against her, then that judgment could be used to attack her personal bank account. That is my mother-in-law's personal bank account. I said, do you want that? Now, she looked at me and the wheels were just processing and she wasn't too sure what exactly I was saying. So I had to take it to another level. And I said, you know what? We live in a community property state here in Washington. If I were sued, then my debts become Tracy's debt, my wife's debt, and that puts your account at risk. Well, that's all it took. And she tore up the paperwork. She said, I don't want to do this. And I said, exactly, you do not want to do this. Not to mention, as soon as you made her a joint tenant and you pass away, everything in your checking account, your savings account becomes Tracy's. And you have another daughter. So you essentially now disinherited her from those assets. She said, oh no, I trust Tracy to do the right thing. Well, of course, Tracy would do the right thing, but then you made it our burden. So that then affects us and how much we can pass on to our kids under our exemption amount. So joint tenancy with right of survivorship. If somebody recommends you need to set up your bank account in that way to avoid probate, say thanks, but I know that's not the way to do it. All right, so what's the second option that people have? Okay, the second option is to name a designated beneficiary. Now, many times banks will tell you it's really simple. All you need to do is come in, specify who the beneficiary is, and then as soon as you pass away, then that person will receive all those funds and avoids probate. Again, accurate information, but does it really work in practice? What are the problems with that approach when it comes to planning for your bank accounts? Well, number one, right? How about if you have 5 beneficiaries? So now you're going to list all 5 individuals on the account. It's doable, but that could make it a little messy potentially for the bank after your passing. But more importantly, my concern as an asset protection attorney is, how about, think about this. If one of your beneficiaries going through a divorce, involved in a lawsuit, and you name them as a designated beneficiary on your account, when you pass, do you realize those assets immediately are going to vest in that beneficiary? That is, they get those assets. So if they have a judgment that is going to be levied against them, the creditors now will have access to your estate. Is that really what you want? Now, that's what can happen when you choose to name someone as a designated beneficiary, but you're saying, I don't want any safeguards, give it to them. And if their life's a mess at that point in time, well, then those assets are going to be part of that mess. And so naming a designated beneficiary, although it sounds simple in practice, which it is, it can have negative ramifications in the future. So I tend to shy away from ever naming a designated beneficiary on an account for that reason. Now, there are limited exceptions to everything. And of course, when I'm looking at an estate and I'm working with someone, if somebody told me, hey, I'm the sole beneficiary of this account, my parents have a small, or my mom has a small account, she's the only survivor, there's no spouse left in the picture, when she passes, it's all going to come to me. Well, maybe that's a situation where we do that. Now, how do we then plan for bank accounts? What is the best solution here? Well, the best solution that I found for personal bank accounts is to set up a living trust, okay? That is it. If you want to plan for your account, you must have a living trust. And so what the living trust is going to do is you're going to retitle your bank account into the name of your trust. So the thing about the trust, and I have several other videos on my channel if you want to learn more about a living trust and why that is the number one estate tool for anyone when it comes to planning for their estate. Be sure to check out those videos, again, to understand what they're about. You see, when you set up a living trust, it does not die. So you can pass away, but the trust continues on. So essentially your bank account, when you retitle it, what do I mean by retitle it? Well, it's real simple. You create your trust. So let's say I created the trust and we're going to call it the Snowbird Trust. So if I create the Snowbird Trust, I'm going to go down to my bank. I walk into Wells Fargo and I explain to them, I've created this trust now, a living trust, and it's called the Snowbird Trust. And I would like to open a new account, because they're going to require you to do this. I want to open up a new account under my living trust name, the Snowbird Trust. Now, if you're listening to this right now and you're thinking, wow, so now I'm going to have a new checking account with the Snowbird Trust on it. How am I ever going to be able to cash checks that say Snowbird Trust? Well, I'll get to that in just a moment. So when you open up this account under your Snowbird Trust, you'll then take your personal account and you'll transfer it into the Snowbird Trust account and you'll close that personal account down. Now your trust holds title. It is the owner of your checking account, your savings account. So if you were to pass away then, the trust continues on. The trustee, your successor trustee, has full control over those checking accounts. All they need to do is go to the bank when you've passed, show the bank the fact that here's a death certificate, show them that this is the successor trustee of the trust, and then that person's in business. They have complete control over those accounts, and there's no probate because a living trust bypasses probate. Now, the benefit to your beneficiaries of adopting this strategy is that let's assume that you have 3 children and one of them is going through a divorce. Do you really want those funds to be distributed to that child during that divorce? Okay, wait till it's satisfied and there's been a decree issued, then you could make those distributions. By having a living trust, you have those provisions that will be baked into it, which states that if my child's involved in a divorce, they're involved in a lawsuit, they have anything that's going on in their life that could put these assets at risk, do not distribute the assets to them. Hold on to them. Wait till those problems are solved, then make the distribution to them. See, the living trust gives you that type of flexibility and that type of control, where when individuals do not use a living trust and they use the 2 methods that I just described, or maybe they have a will and they have to go through probate with the will, you've just taken that off the table. So it makes a lot of sense from an asset protection point of view to be using a living trust to protect these accounts. Now, I talked about the trust and how do your checks read. So here's the thing. I have a living trust set up and I have a checking account in it. Now, my checks do not have my trust name on it. Even though the statements come in and they have the name of the trust on there, the checks read the same way they did before I set up my living trust. It'll have my name on it, my wife's name on it, our address. Anybody who receives that check does not know that that check corresponds to an account that's in a trust. Because when I went and I printed my checks, I specifically requested, do not put the trust name on there. I just want my checks to read as follows. So if you're concerned about that issue, it's a non-issue, right? You can print up your checks anyway. The primary concern should be, how do I make sure that my assets, my bank account, my savings account, do not get hung up in probate? The assets do not get frozen. I've seen that happen to so many individuals who have not followed this advice. Their assets are frozen by the bank. They don't get frozen and they bypass probate. use a living trust for those types of accounts and you will eliminate those issues. Listen, if you're contemplating setting up an estate plan, and you want to know more about how to set one up the right way and what could benefit, how these living trusts can benefit you, hey, go into the show notes and you'll see I have a link in there for a free strategy session. Click on that strategy session. We'll spend some time with you and we'll walk you through the benefits of creating the proper type of estate plan and explain to you how it can help you in your current situation, maybe if you're incapacitated, and what it can do for you and your family into the future. Click on that link right now. Get down there, get your strategy session scheduled to talk about your estate plan, and I wish you the very best with your planning going forwards.